Guthrio, with my practice located here in Burlington, Massachusetts. This is my faithful assistant, Marie Fahey. When you call our office, you'll always end up talking to Marie to start with, and for everyone at home or on remote access, I'll try my best to do the presentation to you as well. We have many people here in the audience, so that we'll have that be our primary focus. For people at home that need some direction, that we do have a website. It's www.guthrolaw.com. That's GUTHROLAW and .com, and you can go on there and you'll find a lot of information that we're going to speak about today. There's also a resources tab, and under the resources tab, there is video resources. And on the video resources tab, you'll find many short 2-3 minute videos that will discuss in detail a lot of the topics that we're going to discuss today. So I think that's a good place to get started. I'd like to thank the Council on Aging and Marge and the team here to provide this great venue for us to meet today. Great that we can all meet, don't you think? Yep, great to all be together. And so this is a legal lunch and learn, and it's for the love of family. Let's do some estate planning. So we'll start it off with that. So as I said, I'm Wendy Guthrio. I do estate planning, elder law, probate. That encompasses wills, trusts, durable powers of attorney, a lot of the documents you see over there, and that I'll hold up shortly, as well as healthcare documents. So today, what we're going to do is I'm going to show you what an estate plan would look like that would give you all of the documents that you need to have to get you through almost anything that comes down the pike at you up until end of life. So each one of the documents I'm going to review with you has a different purpose. So a lot of clients come to me and say, can I just have a will? Or can I just have a trust? And yes, you can have that, but if you really want to make sure that you are ready to address any situation that comes down the pipe, for you to handle, or for your spouse or significant other, or for a child to handle for you, to have the 6 components of the estate plan that I'm going to go over with you today is what will really aid you. So we're going to start by going over the documents specifically, and then I'm going to show you how they work with each other. Now, the first, as most people are familiar with, is called a will, the last will and testament. And so a will is a document where you memorialize what you would like your heirs, or the people that you would like to give your property to and your money to at end of life, that you would normally put those, memorialize that information in a will. It needs to be properly executed. In Massachusetts, that means it needs to name who is going to be in charge of your estate, called the personal representative now. It used to be called the executor or executrix. Now it's called the personal representative. And you name a personal representative, and then you state who you would like to receive your personal property, your bank accounts, your house, and the residuary of your estate. But normally a will is broken up into 3 parts. It is the specific bequests, which is individual items that you'd like to go to one particular person. The next is your personal property, which would be everything that you haven't mentioned with the specific bequest. And then the last part would be the residuary, meaning who would you like to get the rest of your estate? So if you draft a last will and testament, this tells the probate court who you would like, or whom you would like to receive your assets upon your passing. Now, if you noticed, I said it tells the probate court, because when you create a will and you put all that information on this will, you have to then take your will or the personal representative and they bring it to the probate court. So here it would be Middlesex Probate. It's now located in Lowell, Massachusetts. So you open up probate, you submit your will to the probate court. The court says, was this will properly executed? Does it have a personal representative named? Does it have a specific bequest, residuary, the personal property transfers? But more importantly, was it signed by a testator, which would be you, or a testatrix? So was it signed by a person who was competent to sign, over the age of 18, under no duress or undue influence to sign it at the time of the signing? So then, on top of your status, if you're capable and competent to sign a will, it's also going to look, the court is also going to look to see, has this will been signed and notarized, or at least witnessed by two disinterested witnesses? So no one that you're related to, no one that could possibly gain anything from your estate. So you see, you have to have the content of the will, where it disperses all your property. And then once you have the disbursement language, then you have to be capable and competent to sign it. You have to be under no duress or undue influence by anyone. And then you have to have the witnesses looking at you while you are signing this document. So if you have met all of those requirements, you then have a validly executed will in the Commonwealth of Massachusetts. And you could then, upon your passing, your personal representative would then submit this to the probate court, and the probate court does the analysis to make sure all the components are proper. And if they are, then the personal representative that you've named in this will is now going to be in charge of following every word that you wrote on this will. Do the specific bequests, do the personal property distributions, do the residuary distributions. Now, there's the difference between a specific bequest and all your other property. So say I'm going to give this silver bracelet to my daughter, and I want to make sure that it goes to my daughter A as opposed to daughter B. So I have to specifically say, this silver bracelet that has my initials engraved on it to daughter A. But if daughter A does not survive, I have to state what I want to happen. Shall it go to daughter A's children? Maybe it should go to daughter B. So on specific bequests, you have to be specific. So you want to say, if your initial distribution idea fails, then what? So whenever I draft wills for clients, I'm always looking to say, let's figure out if this fails, what's going to happen. And then if that one fails, what's going to happen? So I like to go out 3 gyrations of scenarios so that I know that your desires are being met. So as far as the will, most of my clients think that this avoids probate. I have a will, so I don't have to go to probate. But in fact, a will sets you up for probate. So what clients do if they want to avoid probate is they execute a will, and the name of the will changes from a last will and testament to a pour-over will, because we're going to create a trust. Most of my clients do a revocable living trust. So this trust is simply a container to hold your assets. And I'm going to go into more detail on a trust at the end of reviewing the top 6 cornerstone documents of an estate plan. So what I just want you to know for right now is that a will opens probate and that a trust avoids probate. And it doesn't matter what kind of trust it is. It could be a revocable or an irrevocable. So a will opens probate and a trust avoids probate. Now, there was a lot of information I covered of the components and the information that should be in your will. Well, we have a lot of those same similar components that I want to see in your trust. I want to see who you want to be in charge of your trust when you are no longer here. I want to know who is going to be the beneficiary, just like I did on your will. I want to know specific bequests, just like the will. I want to go out 3 scenarios, just like I did in the will. I want to know then after you're gone, what are we going to do with the trust? Are we going to keep it going for multiple generations? Or are we going to end it? So where I have this will and it opens probate and it has a lot of great information, I also have this trust that avoids probate and it contains pretty much the exact same information. So those are the first 2 documents we're dealing with when we talk about estate planning. Now, the will only comes to fruition upon someone's death. So some people say, well, I put in here, that I want this to go to someone, and so, even while I'm alive, they can take care of that. I'm like, no. This only becomes alive when you're gone. And this speaks for you because you cannot speak for yourself. That's a little different than a trust. Because a revocable living trust in an estate plan is alive and functioning the moment you sign it. And so you don't really have to wait until someone passes for this to be used. It's used during your lifetime to manage your assets, and then it also is alive in a different form once you pass. While you're alive, and if it's for a single person or for a married couple, you can have this trust be using your social security number. So you don't have to get a separate tax identification number while you're alive. But most of the time, upon your passing, whatever you have written in here is set in stone and cannot be changed. So in that way, it kind of starts to look like a will, right? Because this is set in stone and can't be changed once you die as well. But it only comes alive when you die. Where this one is alive through your lifetime and after your lifetime. So then I'm going to move on to what we call the durable power of attorney. So a durable power of attorney is the 3rd cornerstone document of estate plans. And if you want to follow along, that for people here in the audience, you do have a trifold here, and it says preparing your estate plan. And for anyone remotely, this is normally covered in almost a lot of the resource pages or tabs on the website, as well as you can just contact our office at consult@GuthrioLaw.com, and we can either email you one of these or we can send it in the mail. And so this outlines the 6 cornerstone documents that we're speaking about today. So the durable power of attorney. This document, most of my clients use during their lifetime before their will or their trust is ever used. Oftentimes, a durable power of attorney is used when you need someone to handle your finances for you, when you cannot handle them for yourself. This document can be drafted a couple of different ways, and the 2 major ways are: 1, it only comes alive upon your incapacity, and that's called a springing power of attorney. It springs into action upon an event, which would be your incapacity. The other kind is a shifting power of attorney. And that means that you appoint someone to handle your financial affairs for you, whether you have capacity or not. So my example I like to use with my clients is that you name your child as your agent. It's also called your attorney in fact, is the legal name of the person you're going to appoint to handle your finances. So you would name your attorney in fact to handle your financial affairs. In the shifting one, that means you don't have to be incapacitated, right, in order for this to work. So I say to my daughter, who I've named as my power of attorney, Karen, would you please go to the bank and pull out $1,000 for me today? Because I would like to stay at home on the couch and eat bonbons. Karen says, well, it sounds awfully lazy of you, but I'd be happy to do that for you, Wendy. So then Karen would have taken this durable power of attorney. Now, I would have put it on record at the bank long before I'm asking Karen to go to the bank for me so I can eat my bonbons, right? So but Karen could take this with her to the bank. Now, when Karen is standing in front of that teller at the bank, and either the durable power of attorney is on file at the bank already, or she's bringing it to them, that is equivalent to me standing in front of that bank teller and conducting business. Now, this has to have proper execution to it as well. And each one of these documents that we're reviewing here today has its own set of legal requirements in order for them to be valid. So the one thing I find with the durable power of attorney is that we'll draft this, we'll have it be either active upon your incapacity, but I prefer it to be active right now. And I want you to choose someone to act on your financial behalf that you trust emphatically. There can't be a question, don't know if they're going to do the right thing or not. It has to be, no matter what, you trust these people to do the right thing for you. That term is a fiduciary. So you want to make sure that you choose fiduciaries, not necessarily in birth order, or not necessarily in reverse birth order, or not alphabetically. You need to go to your children, your siblings, your friends, spouse, it doesn't matter, but you need to choose someone to be your attorney in fact fiduciary under your power of attorney who you trust emphatically and knows finances, or at least has a better shot at it than maybe somebody that has no capacity to handle finances. But the most important thing with the power of attorney, you want to choose someone that you emphatically trust, and to know that once you have this drafted, I tell all my clients I want you to go immediately to every financial institution and put this on file when it's brand new and fresh. Because one of the pitfalls to a power of attorney that was corrected by law in 2012, but the banks are slow to catch up on this, is that a power of attorney does not expire by the mere fact of time. So now in Massachusetts, any properly executed power of attorney, even if it's 25 years old, it should be valid. But because banks don't really embrace that, because the banks are going to be liable if someone comes with maybe a revoked power of attorney or an expired one, and that they go ahead and do a financial transaction. So on an older power of attorney, the bank will often ask you, could you please get the person, the principal who signed this, to verify that it's still active and that they still want you to act for them. So as I said, that if I sent my daughter to the bank and she's standing in front of the teller and she sees I have $20,000 in my bank account and I've sent her to get 1,000. And she says, I think I'm going to pull all 20,000 out. There's nothing to stop her from doing that because this is on file and she has the power to act as if I was standing in front of that teller and asking to pull out that $20,000. Now, I have a client right now in the hospital, and he did not want a shifting power of attorney, one that's active right now, because he was kind of unsure about these fiduciaries. They lived far away, he didn't have a lot of contact with them. So he did a springing. So now, in the 11th hour, where he's in and out of consciousness, and he needs his mortgage paid, he needs his credit card bills paid, he needs to make sure a direct deposit went in. We are waiting now for him to either have capacity to sign a document that springs it into action, or I have to get a document signed by 2 physicians that says now he lacks capacity to make decisions for himself, so that now it will engage the power of attorney. The other thing is oftentimes when you have those springing powers of attorney, they're not put on file anywhere because they're not really used right now. Versus this one over here, the shifting, it's being used immediately. We're putting it on file. We don't have to wait for somebody to become incapacitated to use it. And you can have the fiduciary you mention in this document handle every financial affair for you where the power of attorney will work. And I say where the power of attorney will work is because the Social Security Administration does not honor powers of attorney that are drafted on any form other than their own. So what we are now suggesting to clients is that when they do have a durable power of attorney, we're starting to provide them with the forms online to become a power of attorney through Social Security, which is called a rep payee. So that form is available online through I think it's the Social Security Administration website. But you can always contact us and we can help facilitate you getting a copy of that form. So the other thing I see in my practice is that a lot of times with investment accounts, either at a Fidelity or a Schwab and Edward Jones, any of those, and all others, by the way, they all have their own proprietary form. And they would much prefer for you to use theirs than to have mine that's 25 pages long and full of information that I want my attorney in fact to be able to do. Where theirs might be a little bit more limiting, but I work with whatever financial house you're working with. We get their form signed, or you can just do it when you go and tell them I want to put my attorney's power of attorney on file. They say, oh, we have our own form. You just say, no problem. I'd like you to put my attorney's on file as well, but I'm happy to complete yours. What I like about my form is that if you have a trust, I do try to name your specific trust, and I say that if you want your fiduciary, your attorney, in fact, to have control of your trust in an emergency event or on a regular event, I can give them those powers. So there's a lot of information in this. You can say whether if you are in a financial perspective and you're doing any annual gifting, which, by the way, it went up to $16,000 per year per person in 2022, that your agent can continue doing your gifting strategy under a durable power of attorney. A lot of the things that I've been telling you about the powers that are in here, these are for assets held in your individual name, compared to an asset that might be held in a trust. If I have a trust and I have a durable power of attorney and my assets are held in this trust, and I'll go into that in a moment, the trust trumps the durable power of attorney. So because a trust is much more powerful, much more inclusive, than a durable power of attorney will ever be. When you go to the bank and you do something from your trust and you're in charge of your trust, namely you're the trustee, the bank doesn't really care what you're pulling out of the bank, what you're doing with the money. If you're a trustee, that's all they care about. Where if you're an agent under a durable power of attorney, is that appointment still valid? Are you allowed to do that under this? So you have a little bit more of a burden to incur if you're just using a durable power of attorney versus if you have your assets in a trust that is designed to avoid probate and make the management of your assets during your lifetime as well as after your lifetime as simple as possible. Everybody with me? Okay, I don't see anybody sleeping, so we're doing okay? Okay. Very good. The next thing we're going to go into is the 3 healthcare documents. We have the healthcare proxy, the HIPAA, and the advanced directive, also called a living will. Who here has a healthcare proxy? Almost everyone. I don't know about you guys out there in remote land, so I hope you're answering yes, you do have a healthcare proxy. Everyone should have a healthcare proxy. So actually, we're thinking about doing a healthcare proxy fair soon, just because I think it's so important that everyone have a healthcare proxy. Healthcare proxy is where you name a fiduciary or a proxy to handle your healthcare decisions. Now, the durable power of attorney, they could handle your financial decisions for you if you had capacity or not, depending upon which one you did. But this healthcare proxy is only geared towards when you have no or little capacity. So this only activates upon your incapacity. It normally requires a medical professional to activate. And this says, if and when I am unable to make healthcare decisions for myself, I name proxy 1 to make those decisions for me. If proxy 1 is not available, then I'm going to name proxy 2. If proxy 2 is not available, I'm going to name proxy 3. Creating this form is fabulous, but communicating what those hard decisions are when the chips are down and you can't speak and the medical profession wants to do all of these fabulous life-sustaining treatments. They want to amputate your leg. They want to do a heart valve replacement. They want to put a dialysis port in. So if you don't have a healthcare proxy, I want you to get it. If you have one, I want you to go to the next step, and I want you to start having courageous conversations with whomever you want to be in charge of your healthcare decisions, and start talking the talk, right? Start having those courageous conversations. Listen, if I'm incapacitated, then yes, I'm okay with a blood transfusion. No, I'm not. I'm okay with taking extreme measures to keep me alive. That's in a different document, but even this, your healthcare agent is really such it's such a tough position to be in for someone. Because like I said in this durable power of attorney, when my daughter was standing in front of the bank teller and she was me, I am the person, my daughter in this case, who's my healthcare agent, she is now me. So she has to make decisions as I would make them. So if you have a healthcare proxy, I encourage you to have conversations with the people, and not just the first agent, the second and the third. This is great family conversation around the Thanksgiving table. So when everybody's together, don't hesitate to just say, okay, I'm going to bring out like all the morbidity and all of that. We're going to talk about if I can't, if I'm injured or if I'm having a healthcare event and I cannot speak for myself. This is what I want you to do for me. I do have someone who just said, how about if I don't want to have that conversation with them? I said, that's fine, but you at least should tell your proxy, whatever you would do for yourself, do for me. I think you've got a good vibe in life. I think you understand medical situations good enough. If it would be good enough for you to make that decision for yourself, then make it for me. Okay, so that's the first healthcare document. The next one is the HIPAA. The HIPAA, everybody familiar with the HIPAA in some capacity? Aren't we tortured at every doctor appointment we go to that they have us fill out a HIPAA form? So when I draft a HIPAA authorization in my office, it's very different from the ones you find in a doctor's office. First of all, I list 3 positions out, 3 gyrations of, that's on the healthcare proxy. On the HIPAA, we're going to name groups of people that will have access, if you want them to your protected healthcare information. So oftentimes, people get a little afraid when they say, oh, they're going to get at my protected healthcare information. Maybe I don't want that. The only time I've really seen that to be a problem is that when we've had any kind of addiction issues that it might be on someone's medical records from a long time ago, some other situation that's very private. But for the most part, we don't really live that many interesting lives that we have that much to hide from people, right? So for a HIPAA authorization, the way I see this used most of the time is someone's been in an accident. They've been transported to a hospital. Maybe this HIPAA is on file at your local hospital or doctor's office. And your sister-in-law or your child calls and says, what's going on? Wendy Guthrio, I think, has been admitted to your hospital. The hospital cannot release any information that you are even in the building. 0. They can't tell anyone anything if they're not on your HIPAA. So if you want your children to be able to call an ER or call a nurse's station or call a doctor and be able to get a status report on you, you should have a HIPAA. Now, your healthcare proxy by law has the same rights as someone who is on your HIPAA. But it doesn't go the reverse way. Not everybody on your HIPAA has the same rights as your healthcare agent. People want to choose 2 people to be their agents on a lot of these documents. And I say, you're asking for trouble. Because have you seen sibling rivalry when one person wants to keep the parent alive and the other one says, I talked to them, they don't want to be alive, right? So that's why you need to choose one person on your healthcare program who's aligned with your desires or your understanding of what you want your healthcare choices to be. Versus on your HIPAA, you could name all of my children and their spouses, all of my grandchildren, 18 years of age or older. You could name my siblings, my parents. You can name specific people. So with this, most of my clients will normally name all of their children and sometimes their grandchildren, 18 years of age or older. And they try to keep that core group as the ones that will call into the hospital, get the medical reports, things like that. I will tell you a funny story. You might not think it's funny. I think it's funny is that I have a woman that came to me and wanted this. And I said, okay, we'll add your husband. She's like, oh, don't add my husband. I said, you don't want your husband? She's like, he is a sky is falling kind of guy. And everything that happens to me, I have a toothache. What do you think it is? What do you think it is? I'm like, my heart hurts. Do you think you need a heart valve replacement? Like, he's like, he would torture me. I don't want him to know. I don't want the doctors talking to him. You can have my kids, but don't have my husband. I'm like, okay. So there's a lot of different ways that all of these documents that I'm speaking of, there's nuances that can be put into these documents to meet whatever your goals are in life. Yes. Yes, the question is, does the HIPAA document allow you to make any healthcare decisions? And the answer is no, it does not. It, as Brenda Pappas said, it only allows you to receive information. You cannot provide direction to the medical. So the last of the three healthcare documents is the Advanced Directive Living Will. Now, many states have fully adopted an Advanced Directive or Living Will statute. Massachusetts is not one of them. But we still create these and put these on file because they give a lot of direction when the chips are down and a decision needs to be made. And when I say chips are down, I mean that, do you want to be kept alive on life support when death is imminent and there's really no chance of survival? Some people are familiar with the Karen Quinlan case from a while ago, Terry Shrivo case. I don't know if I have her name exactly, but those situations came up because there were two parties that had two different positions on what the patient's desires and intentions were. And so because in each one of those cases, there wasn't any documentation of what that individual's wishes would be, then you have competing parties that are just going to make it miserable. So an advanced directive, it's called that in some states, in a living will. And I try to use the word advanced directive because oftentimes people get very confused with living will versus a will. So I use the term advanced directive when I can to make it very clear. We are talking about end-of-life decisions. Now, what makes this document completely different from everything else we've already gone over is that you are not appointing a fiduciary. The words that are written in this document dictate what will be done under certain situations, under certain circumstances. So these are hard decisions. Should we pull the plug or not? Right? So do we need to have specificity in this document? Yes, we do. There is another document that I am not allowed by law to draft, but I encourage each one of you to speak to a medical professional about this document. And I think it complements the Advanced Directive Living Will. And it is a MOLST form. It's called Medical Orders of Life-Sustaining Treatment. It can only be completed by a medical professional, such as a do not resuscitate order can only be completed by a medical professional. But this one has a lot more specificity to it. And so if you use this and you have this, such as this goes into a little bit more detail. Do not resuscitate, attempt resuscitation. Do you want to be on a ventilator? Do you want to be transferred to a hospital? Do you want to stay at home? There are some people that really feel they're fine, they've put enough life in, they're ready. So a lot of people have this on bright pen paper and put it on their refrigerator, and paramedics are trained to look for this. So if you have one of these and it's sitting in a drawer, you might want to think about taking it out and putting it on your refrigerator or someplace that can be seen. The back of it goes into a little bit more detail. Do you want to be intubated and ventilated? What type? Do you want artificial nutrition? Do you want artificial hydration? Do you want dialysis? And there's spaces here that you can fill in. Under these circumstances, I do. Under this circumstance, I don't. Now, I I said to you earlier that your healthcare proxy has a lot of power, right? Make all these healthcare decisions for you. I have seen in some situations, in some medical environments, that even when you have said on this advanced directive, you know, death is imminent, don't do any extreme measures. The healthcare proxy sometimes has the ability to say, I know mom said this, or I know dad said this, but could you at least try this? And then we'll move into the end of the end of life care. So I don't want you to feel like it's so set in stone, but that the healthcare proxy can sometimes intervene at some medical institutions. But I have a client a couple months ago who passed away, and that they did have this on file, and that it was much easier for the family, much easier for the kids, that when the children were going back and forth of what they should do, the doctor said, this really is a critical situation. Your parent really doesn't have a lot of quality of life left. If that's your basis for determining, your parent made that decision long ago, that if there was no quality, then it's okay to take those extreme measures. Everybody with me? So we got 6 documents, right? We've got the will, we've got the trust, we've got the durable power of attorney that handles finances, and we have 3 healthcare documents. The healthcare proxy, the person that's going to handle your medical decisions that you're going to have courageous conversations with. Your HIPAA, the people that can find out if you're in the hospital and what your medical status is. And the advanced directive, which is end of life, whether or not you want to be kept alive on life support if death is imminent. I'll take questions at the end, so I'm going to move right into the final part of the presentation, which is to talk a little bit about trust. Because for a lot of people, they're very foreign things that you can't really wrap your head around it. And as I said, we had 2 scenarios with documents here, right? We had a will that opens probate, and we have a trust that avoids probate. So let's talk about a probate avoidance trust, because many clients want to avoid probate. I'm going to start by telling you what probate is. Probate is the act of retitling assets into a new owner's name. My silver bracelet, my will says, give it to daughter A, goes to probate. The court says, great, we're going to give this bracelet to daughter A after 1 year, because we have to make sure that there aren't any creditor claims that might have a claim on any estate assets, that we could liquidate this silver bracelet and pay off maybe a Medicaid mass health claim, whether it's the driveway that you have paved that you haven't fully paid for, the landscaping bill that was the last one that was on your estate before you passed. So you have a tax bill, a lien on a tax bill is not uncommon for property taxes, I find. So my daughter cannot get this bracelet until I open probate. It spends 1 year in the courts. I get the will evaluated to make sure that it had all of the proper signing mechanisms to it, and that after 1 year, if no creditors have made a claim on my estate, then my personal representative will give daughter A the bracelet. Same thing with bank accounts. So anything that's going to go through your will, you're going to have to tie it up in the probate process, in the probate court, for a minimum of 1 year. The biggest negative to that, I think, because I also do Medicaid and mass health planning for the event you need to go into a skilled nursing facility, is that the only mechanism, pretty much the only mechanism that mass health has, Medicaid has, for being made whole and getting paid back for any money that they have fronted on your behalf for your care, if you used any of their services, is through the probate process. So if none of your assets ever have to go to probate, MassHealth is never going to be reimbursed for services rendered. But don't worry, MassHealth has a great system in place to make sure that your assets pass through probate so that they can be made whole upon your passing. Okay, so we're going to talk about trust. I'd like you to think about a trust as simply a container to hold things. Okay, so here we have this container that is not sticky. So if you'll see, this is simply an empty container. Now, this happens to be a revocable trust because those are the words I wrote on it. And this normally runs about 25 to 40 pages to really cover any scenario coming down the pike. There are shorter ones, but for me as an estate planning professional, I know the situations that happen in life, and I really want to prepare my clients for whatever comes down the pike. So, a revocable trust. Revocable meaning it can be changed, it can be revoked. Some of the important things are that in a revocable trust, you are the grantor, meaning that you take your property and you grant it or donate it into this trust. You are the trustee of this trust. And that means that you are in charge of following all of the words, all of the direction that you crafted, that you told me that you want this trust to do. You are in charge of following the letter of the law on the content of the trust. Your next position is that you are the beneficiary. That means that when you're in all three positions, and beneficiary means that you get to benefit by all the assets that are held in this trust. So with that said, if you are in all three positions, you are the grantor, you are the trustee, and you are the beneficiary. It's the equivalent of you owning the asset outright in your own name. So I have a trust, a revocable trust. I also have a small bank account on the side that I have my daughter on the title of it with me. So, and then I have another, for example, I don't have this, but if I had another bank account that I just had in my own name, that bank account uses my Social Security number. My trust uses my Social Security number. So when I die, I take my Social Security number with me, but my trust survives me. And I name who I want to be the trustee after I'm gone. So now they're going to have to follow the letter of the law on the trust. It gets a new Social Security number or a tax identification number. Now, as I was saying, that this revocable trust, I can change it. I can revoke it. It avoids probate. It's private because I don't need to go through the probate court on this. I don't record this document at the probate court. And then I stay in control of everything in here. So if I transferred my $20,000 bank account into this, and now it is now Wendy Guthrio as trustee of the Wendy Guthrio Revocable Trust. Wendy Guthrio goes to the bank and gets her $20,000 out. Wendy Guthrio goes and writes a check for $5,000. I deposit money into it. Whatever you are doing with your own personal accounts right now, you can do with this revocable trust. Now, the benefit of this trust really is that it avoids probate. So the other benefit is that you can have a lot of different types of revocable trusts. You can have a tax planning trust so that Massachusetts has a very low taxable threshold when you die. If you die owning 1 penny over $1 million, that includes real estate, life insurance policies, 401ks, personal property, vehicles, annuities, goes on and on. even if you have a named beneficiary on it, the Department of Revenue and the IRS takes a snapshot of every asset that you have your Social Security number connected to the second before you die. And that is what is encompassed in your taxable estate for Massachusetts estate taxes. So a penny over $1 million, you're going to probably pay about a $40,000 tax, and it goes up further. So you can also do this type of trust as tax planning trust, so that you can at least protect $2 million in your estate without having tax. Now, it's a great problem to have, isn't it? So if we're lucky enough to have those problems, the trust that not only avoids probate can also be a tax planning trust for you. So again, we're going to fund this trust now. So because it's a container and it holds things, the only way that you can avoid probate on your assets is to get your assets into the bucket. You have to get them into the container. So that's what we're going to do now. We're going to take this revocable trust container, and if you came to me and said, Wendy, could you please do my estate plan? I'd like a revocable trust. I would say, very good. Do you own any real estate? Yes, I own 1 or 2 houses, 1 house. I am going to take the deed to your house, which is in your individual name, and I am going to transfer this by doing a new deed. And I'm going to, in my example, it would be Wendy Guthrio of 17 Treetop Court in Burlington is going to transfer her deed to Wendy Guthrio as trustee of the Guthrio Revocable Trust. And then I record that at the Registry of Deeds. And when I record it, it is then part of your trust, and you have now successfully funded your trust with an asset. Now, then, I also do an assignment of personal property. And so what I do is I take one document. You don't have to write down what your property is at all, but I just say whatever it is, I'm transferring that into your trust. And I fund your trust with your personal property. Then I give you instructions, or you can hire our firm to do funding, which this is included in all of the plans that we do for trust. If you have real estate, we include that. And the personal property is included as well. This is a bigger task to actually get your money into the bucket, into the container. So we give you very specific information on, well, what kind of monetary asset are we talking about? Is it a bank account? Is it a CD? Is it a stock and bond portfolio, mutual funds that maybe aren't held at a brokerage firm? So whatever it is, and however you get it in, whether you hire me to do it or you follow the instructions I give you, you need to get those into your trust. Right? So now we have a trust bucket that is funded with your assets, so that in my case, when I die, I've got all my assets in this one container. So my daughter, when she is the successor trustee of my trust, she is going to then contact my CPA or attorney, get a new tax ID number for my trust, and she's going to read all of the words that we had said were in the will and the trust earlier, right? They were pretty much all the same. And we were going to make those distributions to those beneficiaries. And if one of them is predeceased, we're going to go out to the second line and then the third line. So having this revocable trust and funding it is so helpful to avoid probate no matter what. We still use a will in case the day before a month before you passed away, maybe you received an inheritance and you didn't get a chance to transfer that inheritance into your trust. We have a will that says, pour everything into the trust. You still have to open up probate, but it's a very abbreviated probate in a much shorter period of time. So to finish up the presentation, there's a couple things I want to tell you about trust, right? This revocable trust for estate planning. Anyone in the audience have any savings bonds? Right? So I'd like you to pull out your savings bonds when you go home today. And I would like you to figure out, are they in your individual name? Are they jointly titled with someone else? Do you have a named beneficiary of once you pass, if you don't cash them in during your lifetime, who is going to inherit them? So to do that, it will be very useful because I want you to do an evaluation. Should you transfer your savings bonds into your trust if you have a trust? Maybe they've already reached maturity. Maybe you've already gotten your money. Maybe you just haven't cashed them because it's inconvenient. We do have documentation that we've brought with us, which are instructions of how to redeem paper savings bonds. I looked at my old savings bonds a couple of years ago, and surprise to me, my boyfriend's name was on it from before I got married. So I think I'll redeem that savings bond and clean up that mess, right? So you can retitle them into the name of your trust or into a new owner. You can keep them if you want, but to realize they're going to be part of your probate estate. You're going to go through that 1 year in probate with savings bonds that don't have a named beneficiary on them or are not jointly titled, right? So look at your savings bonds. You really want to see how they're titled. And I do recommend if they've reached maturity, you might want to think about redeeming them because I do a lot of probates and it is a hassle to do the savings bonds. It takes a lot of time. I have some clients that have hundreds of thousands of dollars in savings bonds because when they got married, they were given a $50 bond or a $100 bond, and it was a large part of a savings program encouraged by the federal government for many, many years. So take a look, see if you can pull out your savings bond and address that situation. And we can retitle them into a trust if you want. So our last thing I really want to talk to you about is retirement benefits. Because retirement benefits, whether it be an IRA that you have, a 401k, CDs, annuities, pensions, anything that I consider retirement is money that when you received it, you weren't taxed on. It's also called qualified money because it has these conditions around it. So if you've noticed on an IRA, when you maybe, and it's an IRA CD, say, and it comes to fruition that you need to renew it, and you're like, I'm going to cash it out. You cash it out, say it's $1,000, you're going to get a 1099 on that because you have to claim that as ordinary income and be taxed on it because you were never taxed on it originally. So qualified money, retirement money, is handled very differently than all these other assets that I just reviewed. Now, depending upon what type of trust I draft for you, we can put retirement money in there. It's called a conduit trust. And I have some special language that allows named beneficiaries to receive the asset as if it was given directly to them from the IRA or CD. But that a lot of people that have these assets and a trust, they opt to name their surviving spouse as the beneficiary of it, and then maybe after that, they might name the trust. Or they'll name their 3 children equally and then name the trust. One of the reasons why people like these assets, everything actually being in here, as opposed to just leaving assets outright to somebody without a trust, is that all of my trusts have language in the event someone becomes incapacitated and is on public benefits. We don't want assets to go to a child or a grandchild or a surviving spouse that might be in a nursing home. We don't want assets to pass to them to disturb their public benefits if we've just gotten them on mass health, or if it's a special needs child that's under an IEP now at school and we're unsure about whether they're really going to need a higher level of services and go on social supplemental security income. So all trusts that we draft, when we can, have a special needs function in them so that we don't disturb benefits. And that would include that if we have retirement assets, that if you just wrote down all 3 children's names as the beneficiaries on this, and one of your beneficiaries was a special needs person, then the money is going to them, even if it's going to disturb their public benefits. Where if we do this trust, we often can avoid that situation. In addition, we can just create a special needs trust outside of it and make sure your assets go to that special needs trust, or the beneficiary designation form on the IRA CD that we talked about earlier actually has the name of the special needs trust for that disabled beneficiary. So, as I said at the beginning, we have cornerstone documents that are associated with estate planning. Your will, your trust, your durable power of attorney, and your 3 healthcare documents. It is my contention is that if you have all of these documents in place, that we can pretty much deal with no matter what comes down the pipe, and that it's important for you to draft these documents while you are competent and capable and can make really great decisions on who you want your people to be to take care of you, either when you're active and vibrant and nothing's going on, or when the chips are down, that you know that you have your plan in place. So with that, that's pretty much the presentation. I will mention to you that we'll be doing future presentations for the Lunch and Learn, and one of them is going to be about irrevocable trusts. And these are a different type of trust than what we've spoken about today. And this is used for asset protection, Medicaid planning. You might be familiar with the 5-year look-back rule, that these trusts qualify for a 5-year look-back rule. And so this, you cannot change it, you cannot revoke it, except you might be able to tell people that you want a different beneficiary through your will. That's a conversation for the next class. And you need to be able to divest yourself of assets in order to start the 5-year look-back period, which is very different from this, right? Because you have total control right up until the end. Here, you have lost almost all control. But that's how you protect assets. Very good. Thank you very much. I enjoyed being here. Happy Valentine's Day, everyone. Thank you. Yes. Yes, we're putting materials together that we'll be happy to. And this is being, do you know if this is being recorded, Brenda? Or is it just live stream? Okay, very good. We'll see if there's, and also that on my website, GuthrioLaw.com, under resources videos, there is a video on just about everything I've spoken about as well. But the trifold here is really your go-to document to kind of reflect on, to get an understanding of each one of these documents and how they work together. You're welcome. Yes. Yes, that's a good question. The question is, the information that's in the healthcare proxy, is that also included in the advanced directive? Well, the advanced directive is a document that really is only for end-of-life decision-making. You could, but that you're really trusting your healthcare agent to make those decisions for you. When you do estate planning documents with my firm, I have a separate document that I have you and your proxy review and sign so that you've gone over the list of what happens if this and this and this, so that you don't need to have those specific situations detailed, because it's changing. You know, that what you feel, some of my clients are 25 years old, and what they're going to feel like when they're 80 might be a little different than when they're 25, but their healthcare agent is often the same person. So yes, to answer your question, you can put it in the document, but it's normally not recommended. Yes.
And then 5 years later, you decide to change your executor. How, so now the 5-year-old person has got this piece of paper. How
Okay.
is it documented which one?
So the question is, if you have executed a durable power of attorney for finances, and you put it on file with the bank, and then you've now decided to change who your agent is going to be, your attorney in fact, how do you stop the first person from using, the first agent from using it, because they're no longer qualified? So what we do is that we create the new document, and we say on the new document that it revokes all previous powers of attorney, and you should keep track of every place that you have provided your power of attorney, and you need to alert them that you have revoked person A's powers, and here are your new powers. And if you're not giving someone new powers and you just want to revoke the old powers, you can go to the bank or the financial institution and specifically tell them you'd like to revoke it. They'll ask you to put it in writing. So you can either use one of their forms or write something out yourself that I hereby revoke my previous power of attorney that was executed in favor of. And please do not allow them to conduct financial transactions on my name. Yes. Yes, Pat. Great question. Yes, Pat asks, if you're opening up a new bank account, should you bring a copy of your trust? So if this is my trust, right, I'm taking my trust with me to the bank, taking my document, no matter how many pages it is, right, taking it to the bank, putting it on file. They will normally scan it. You never give your original. You always tell them to just take a copy or a scan. You keep your original documents, all of them. So you bring it to the bank. They normally have to scan it and submit it to headquarters. They have their legal department look at it to make sure it's accurate and properly executed. You normally have to wait 5 days. It comes back that it's approved. And at that point, then they'll normally open up the bank account in the name of the trust. You can say whether you want it to be whose social security number is going to be used for the trust. And then after you do that, you're ready to then start transferring your bank accounts into the trust. Yes. Oh, did you have a follow-up question? Yes.
I wanted to talk about bloodline planning.
Bloodline planning?
Yeah.
So do you have a specific question about it? Yes. The other person is their spouse? Okay. So if you didn't have any estate planning documents in order, the laws of Massachusetts will control. And if it's what I call a nuclear family, husband, wife, joint children of the husband and wife, and then you have children and grandchildren. So if you have that nuclear kind of leave it to beaver family environment, right? Then what happens is that your assets transfer to your surviving spouse. Still have to go through probate, but that's what would happen. If your surviving spouse predeceased you, it would go equally to your children. If one of your children had predeceased you but left children, it would go to them. So Pat, I go into this detail because you see that the bloodline has been preserved. So Pat wants to make sure that her assets stay in the bloodline and don't go to any of the in-laws, which we endearingly call them in estate planning, the outlaws. So most of the planning is done to keep things in the bloodline. And if you don't want it in the bloodline and you want it to go to a surviving daughter-in-law, son-in-law, someone who is not family, then that has to be drafted into your documents. There was a question on the back table? Yes.
And the will is with a, like, not married to me.
Right. So the question is, if when you originally drafted your will 20 years ago and you had a minor child or a child that was not married and now they're married and they have a new name, does that negate the will or does it require any action? So no, it does not. But that is why on my documents, I always give a title to the person when I can. My daughter, Jeanette, my son, Harold, so that we can at least, and I use their first and last name, and that you can normally, with a will, it's not normally a problem because it's the personal representative that's going to be in charge of everything in your will. So if your personal representative is in charge of everything and it's going through the probate process, the court doesn't look closely at the actual names of the people because that's the job of the personal representative. So as long as the person that you've chosen as the personal representative can figure that out, then it's really a non-issue. So I would not encourage somebody who had a will that was very well executed and functioning for every reason but that to ever invest the money in getting a new will. There are other reasons for older wills, like there's different types of probate that are available that you can save yourself some time and money by doing, having these things in the will. The other thing is that you really want to look, if you have current wills at home, you want to make sure that your old will gives your personal representative or your executor or executrix the power to sell your real estate. Because if it does not, that's going to cost you another $2,000 to get that through probate. Probate with a house normally runs about $5,000 to $8,000 in 1 year, minimum. I mean, I've had probates go as high as $23,000, $25,000. I've had them go as little as, when it was a voluntary and all I had to do was probate a car, that was $1,500. But from a probate perspective, that depending upon your assets, right? So anything in this, we avoid probate. But if we're going through the probate process, you have to look. So if all of these assets, right, are in, if all these assets now have to go through probate, your personal property, the deed to your house, all your bank accounts, right? So it's going to just be more burdensome for not only your personal representative, but for your probate attorney to work with your personal representative. You have to do an accounting normally at the end of probate. So all the money that was in your estate the second that you passed away, up until how every cent was distributed when we closed probate and all of the beneficiaries got their money. Yes. That, yeah. Yes.
Well,
Unless you choose otherwise. Right. Right. But I will tell you that if you have given 1/3 of your estate to one of your children and they survive you in Massachusetts, the rule is they have to survive you by 30 days. And then your child dies 32 days after you. Well, their 1/3 vested in them, even though they're not here to actually get it, their estate gets it. And if your child had a will or not, and it said, my surviving spouse gets everything, they're going to get it. Right. So, but I'm just saying that even though you do that, there are these conditions. Right. Yes. This revocable trust? Yeah. Are you at Center Street? Yeah. So, first of all, I think we live in a great town. If you're all from Burlington, I just think that just even to have this great Council on Aging and all of the programs and services that they provide, and that they have programs to help us stay in Burlington. As we all know, the tax base is going up, that the ability for us to live in this town is getting more expensive, and that they have housing alternatives. They have some senior housing, and then we also have the condos over at Center Street. So those condos, because they have a deed restriction on them, that keeps them affordable. So if I remember correctly, I'm not totally well versed in this, but my understanding is that you buy it, and when you sell it, or your estate sells it, your estate or you cannot make more than a 10% profit on that condominium. So in order to have that deed restriction in place, that has to have some conditions on it, because you don't really totally own that. You do. You pay the condo fee. You pay maybe a monthly mortgage on it. But there is an intermediary step on that. And it says, you own it, but you can't sell it. The town of Burlington can sell it, or the housing authority, I don't know. Brenda, do you know who's the seller? Oh, there you go. Okay.
And family to find the buyer. And we have a specific list that we go by. And one of the things in the deed restriction was not properly spelled out that it shouldn't be in a trust. Because they don't, you're right, if they do own it, but then the family doesn't. So
Right.
So it became a
So for those people that are joining us remotely, Sandy is here, who's in charge of the resales of those condominiums. So with that said, she said that there is, the things I said to you are correct, that there is the restriction, and that the family gives Sandy the right to then go ahead and sell it. So to Sandy's confirming that you cannot put this deed into the revocable trust, because it's not really the family's to sell 100%. So there are some things that I think we might be able to do, Sandy. I'd be happy to talk to you about it. Maybe we could even do some type of change for the actual underlying deed restriction that would allow us to put it into a trust to avoid probate, but that it has to go back to Sandy to do the resale.
town.
Yes, Pat. Pat, I'm full of sad questions, sad scenarios. Yes. It only went away for 1 year. The year that Steinbrenner died. That was the 1 year it went away from a federal basis. But we've always had the $1 million. They're always discussing it.
Right.
And the Commonwealth of Mass, that's where they make a lot of money, through the taxation. And I think if you look at it like this, if you look at it from like a social science perspective, is that we come into this world and we don't really have anything, and they give you tax incentives to try to start a family, to get married, and then they incentivize IRAs and 401k so that you have retirement money saved. And then after that, Then they start making you take required minimum distributions. So you start pulling that money out and you lose a lot of tax credits, and they want you to start spending your money and using it. So you can see they try to give you programs that help you develop wealth, and then they want you to start using wealth so that when you pass, your wealth has been used, and that society is, they're supposed to, the goal is for society to be better. So if you haven't spent it all, they're going to help you better society by doing a redistribution of wealth by taxing estates 1 penny over $1 million. Nope. They go, if you're a penny over $1 million, they tax from 0 up. That's why you get an immediate $40,000 hit. And by the way, I am not a financial advisor. I'm not a CPA. I don't know taxes. I just have to know some things for this, but I'm not qualified to give you financial or tax advice.
Same Social Security number.
Yes.
Justify.
No. If you tell your accountant, or if you're doing your own, that you have income generated from your trust, then they include that on your personal tax return. It might be like a K-1 report, if there's any accountants in the room, something like that, so that you don't have to. This trust would be different, but this one, it's normally just a part of your regular tax return. You're welcome. Yes.
One thing that didn't get in the trust, does that mean everything has to go to?
No. The question is, if you get all of your assets into the probate container, and then, excuse me, thank you. If you get all of your assets into the trust container, but you maybe you left out vacation property. So when you do have to open up probate, so then you take your will, you open up probate, and you tell the court on your inventory, the only thing that you're probating is this deed. So this goes through probate, and then when I do this, when I have a trust, I call this a pour-over will. And what I say is, if I didn't get any assets in, like this deed upon my death, that when I open up probate, open it, pour everything into the container, and close probate. I still have the restrictions, I have to wait a year and things like that, but I at least don't have to manage everything with the probate court, with sending accounting, so, you know, dealing with all of that. So it makes it a much quicker process if you have to pour it in. Yes. Yes. The question is, if you have a deed and it has 3 people's names on it, oftentimes it would be a husband and a wife and a child or multiple children, does this have to go to probate? And the answer is no. And that answer applies to money as well. Savings bonds, that's another example, right? Bank accounts, which is why I was asking you on the savings bonds. Is it jointly owned with someone? Because the example that we're talking about right now, your house is jointly owned with someone if they're on the deed with you. If you have a husband and wife bank account, or you have a bank account titled with the child, doesn't need to go to probate because you are all owners during your lifetime. Now, the reason why people don't want to add other people onto their deed is that there's tax effects of that. So the one tax effect that they just tried to change in the last go-round on the federal tax code that was being tried to change was that if you bought your house at $25,000, and when you die, your house is worth $525,000, and you put it into your trust, and your trust says, on my death, give my house to my 2 children. Well, your children would inherit your house at the value of whatever the house was when you died, $500,000. Versus in your situation that you're speaking of, if this deed has 3 people on it, each person is a 1/3 interest owner. So if you gifted the house you bought at $30,000 into you have it, your deed 30,000, you have $10,000 worth of value, your spouse has 10,000, and your child has 10,000. So whatever, that's called a basis. Again, that's disclaimer, I don't do taxes. But that's your cost basis, your basis of whatever you paid for an asset, plus capital improvements, determines what basis you have. So in your example, say you have a child on it, your child has your basis in 1/3 of the house. And then you do need an accountant to help figure out, when you and your spouse die, what value did your children inherit the house at? So it's very clear when you own the house, you had a very low basis, you bought it for very low money, and then you own it fully when you pass away. Either when you put it into your trust and avoid probate, it gets a step up in basis to your date of death value. Or if you go through the probate process 1 year with your will, right? What happened to my will? But so with the will, and you're now taking it through the probate, it's going to get a step up in basis to your date of death value under current law. So this is when we need the CPA. What I can tell you is that when you have a life, so the question is, what happens if you have a life estate? What is it the same situation? So a life estate deed is very different from a regular deed where a husband and wife or an individual owns it. So what you have is, we're going to say a husband and wife own this deed. And then it's a very common scenario for doing Medicaid planning for a mass health application, or in the event you need a nursing home. Some people in the past have taken their deed and they have transferred it to their children. And so the deed would say, I, Wendy Guthrio, transfer my deed to my daughter Karen, but I reserve the right to live in the house for the rest of my life. Or if I decide to rent the house and live someplace else, I'm entitled to the income generated from that rental. So to your question, that is what, first of all, a life estate on a deed is. So this is when I've gotten 2 different responses, and I really can't speak to that question, but it will be viewed one of 2 ways. It will be viewed that your life estate has a certain value of it based upon how old you are and the value of the house. And they figure out what your life expectancy is. And they say, oh, well, when you transferred it, you had about 25% life expectancy. So you retain a 25% interest in your house. And that other 75%, you gifted to your children. So I gifted 75% to Karen. I retained 25% in a life estate. So we need to talk to a financial person to tell us how that would be taxed. And do you get a step up in basis at time of death to 75% to 25%? Okay. So I think I've answered all the questions. Marie and I will be here. Oh, yes. So the question is, if you have validly executed Massachusetts estate planning documents, do you need to, and you move to another state such as Florida, which is a common move here, do you need new estate planning documents? Well, if you have a tax planning trust, the tax code in Florida is very different from the tax code here in Massachusetts. So you don't need to do that tax planning, the $1 million exemptions and things like that. So I would like you to at least consult a Florida attorney or another state attorney to say, can you amend my trust so that it uses, it's called the situs of the trust would be Florida then, as opposed to Massachusetts or whatever other state. As far as your other documents, realistically, under the Constitution of the United States, under the full faith and credit clause, any validly executed document in one state should be honored by another state. In practice, not so clean. So I don't discourage people, but I think push come to shove, they would take them. But I think it would be easier. I try to have all of my documents executed with 2 witnesses and a notary, which is really the largest benchmark across the United States, so that you have. Very good. Well, thank you all so much. Yep, and I'll answer any other questions that you have after. Thank you.